So just a bit about me, so you know what my background is and why I've chosen to talk to you about this today. I sort of have these two parallel interests that have been running side by side. So I have the natural medicine interest. I've got a certificate of permaculture and a diploma of yoga teaching. I used to practice as a yoga teacher for some time. An advanced diploma of naturopathy through Endeavour College, so I'm an alumni of the college. And also a Bachelor of Science majoring in genetics. And with those kind of areas of interest, I've founded this company called Plant Matter Ventures, and we manufacture and sell raw vegan food through Flannery's, the IGA, Go Vita, Paleo Cafe, Raw, which is a chain of stores in Brisbane, a few others. So we sort of I have that sort of interest, and then parallel with that, I have my legal interests. I've got a Bachelor of Laws, a graduate diploma of legal practice, and a Masters of Industrial Property Law, and I'm registered as a patent and trademarks attorney in Australia and New Zealand, an attorney in New York, and an intellectual property lawyer in Australia, and that's currently what I'm working as a lawyer here in Brisbane. Through working with emerging companies through my job as a lawyer, and also when I was in New York, I worked as advisor to startup companies, including natural medicine ones like naturopathy practices, natural juices and snack foods companies. So through this experience, I've discovered that there are a number of recurrent themes, questions that people have. So I've tried to focus on them tonight, but obviously you're all busy, you've tuned in because you have things maybe that you want to know, so I'm very happy for everyone to stop me at any point in time and direct this towards what will help you rather than whatever I think you might want to know.
Absolutely. Yeah, and just if I can jump in at that point, folks, just ask questions, type furiously, and Rally and my job will be to you know, grab those questions and get them in as we go. Thanks, Hayley.
Perfect. Okay, so just starting on some very fundamental basics, like what is intellectual property? And intellectual property encompasses a bunch of things that might be trademarks, patents, designs, copyright, and then there's a bunch of other more obscure rights like plant breeders' rights. So if you crossbreed two different plants and you come up with a really amazing plant that produces a particular type of mango, for example, you can get a right to protect that breed of mango plant. But we're not going to cover all of these because there's obviously a lot of information to cover, and already probably tonight it's going to be an information dump. So I think what we'll focus on is trademarks primarily, because that's probably for most of you the most relevant, and then maybe a little bit of copyright towards the end. But obviously if you have any questions about any of the other types of intellectual property rights, if you think you've come up with a really novel formula for a new herbal medicine, for example, and you want to know about patenting it, you can definitely come and talk to me afterwards. The next question that I've got on that slide is, what is a brand? Basically, a brand is just a non-lawyer's term for a trademark, so it's nothing different. It's just either your written version of your trademark or your logo version of the trademark, and they together form your brand.
It's interesting though, don't you think, that more and more these days, Hayley, people are talking about their own personal brand as in themselves as well, in addition to their logo?
Yeah, it's always been the case that you have very good rights to register your own name as a trademark, and that you should always have the right to use your own name. So I suppose to the extent that people are marketing themselves more and more as their own brand, that it's relevant that the law has sort of acknowledged that not only now but previously, so you have good rights in using your own name. Okay, so the next question is, when is it necessary to protect your intellectual property? And my answer to that, obviously, as an intellectual property lawyer, is always. That's probably because I see the worst that can happen if you don't properly protect your intellectual property. But there's also less sort of, I guess, catastrophizing reasons for wanting to protect your intellectual property. There's also positive reasons to do it. If you evaluate the Fortune 100 companies, so the top 100 companies in the world, nearly 76% of each of the companies' value arises from their intellectual property assets. So not their tangible assets, not their buildings, not the cars that they own, but the intangible assets, their IP rights. So that means if that's also the case for you in your business, then you probably take a lot of care to protect your tangible assets. So if you have stock in your stocks of herbs, for example, you probably keep that at the right temperature so it doesn't perish. You probably keep it locked up at night so no one can take it. So you probably insure it. So you've got a number of measures in place to protect your tangible assets, but potentially those assets are only about 24% of the total value of your business. So you need to be taking note of the other 76% of the value of your business, and take the steps that you need to take to protect those intellectual property assets as well.
So as Hayley's going to the next slide, how about we do a quick poll, folks? I know that most of you, or you've all graduated from Endeavour College, and many of you will be delivering natural medicine, so you'll be running your own practices. But just as Hayley's talking, can you jot down, please, for us all, if you've written any books, if you've developed or want to develop any products, and what those might be. In what area are those products? Thanks, Hayley.
Yeah, and in anything that you do, I mean, it doesn't have to be a product or a book, even just opening up your own practice. If you're providing a service, a naturopathy service, then that is something that is protectable. Your business name, however you brand your naturopathy business, that's protectable as a trademark. So in terms of when to protect it, from my perspective, the sooner the better. So intellectual property laws can be quite unforgiving. If you, for example, disclose some information that would otherwise be protectable as a trade secret or confidential information, once it's disclosed, you can no longer protect it. It's out there in the general public. If you have an idea, so a formula that you could have potentially patented, but you then go and share that with other people, then that formula is no longer novel, so you've lost your rights in it. Equally, if you start using a trademark and someone else sees, oh, that's a really good mark, I want to use it, they can file an application for registration of that mark before you, and they then have rights that can be difficult to overcome. So basically, you need to get in there as quickly as possible and then be vigilant about protecting your rights, because if you don't, you can, in many cases, lose your rights. A lot of people come to me and they say, okay, well, I have a registered business name, I've got a company name, even sometimes I've got a domain name, so I'm protected. Unfortunately, that's not the case, and we just talk about what business names and company names and domain names are and why they're not the same as getting a trademark registration. So a business name you need, right, because you need to pay GST, and that's done through a business name, or it's done through an ABN. And when you want to trade, if you don't want to trade as your own name, you can then trade under the business name. A company name you don't have to have, but it's probably good to have one, and if you need more information about that, feel free to contact us. Basically, there's a couple of reasons why it's a good idea. The first one is for liability purposes. So if somebody sues you, then normally if you're just trading as a sole trader, they can sue you directly, in your car or your house or whatever assets you have are fair game for the person that's suing you. If you're trading through a company, the person will be required to sue the company, and then the company assets are fair game, but your individual personal assets are generally protected. And the second reason is tax considerations. So company tax in Australia is 30%, and depending on how much you earn, and when you first start you probably won't be earning over the threshold, but as you increase your earnings, individual income tax is higher than company tax, so you'd pay more if you don't operate through a company. So that's some reasons why they're either necessary or beneficial, but they don't actually protect the name that you select. All that ASIC, the organisation where you register your business and company name through, all that will do is check that there's no other identical name to what you want, and as long as it's not identical, they'll generally let you have it. It doesn't give you any exclusive rights in it. Again, same with the domain name. They'll check that no one's got anything identical, and then if not, they'll let you have it, but it doesn't give you exclusive rights in it. So to get exclusive rights in a trademark, you need to get a trademark registration. Well, do you know, Riley, what was interesting? I dropped in to see you the other day, and I brought those products that those girls had just shown me, and they'd said, oh, can you help us? We want to register this mark as a trademark now. We've taken all the steps. And so they had got T-shirts made up, and they'd been selling it already through some stores, and so they'd really developed some goodwill. They were giving out free samples under this brand name. So they'd invested a lot of time and effort. Probably not that much money, but to them at early stages in a business, it was a fair amount of money. So I came back after talking to you. I went onto the ATMOS, the Australian Trademarks Database, and it took me 2 seconds to see that that mark is not available. Someone else has got it. So I had to go back to those girls and tell them the bad news, that all that time and effort and the goodwill that they'd generated and all of that was probably in vain, because they're really going to have a problem, and they probably would be best to change their name. So it's really good that people are thinking about this as early as possible, so that they're not wasting that time and money and effort and everything, and then having to go back to square one when they find out the bad news that the trademark's not available.
Very cool.
Okay, so when you select a trademark, first thing to think of is make sure that it's a distinctive mark. Don't pick something descriptive. So if you live in Brisbane and you're starting a naturopathy practice, Brisbane naturopathy specialists is probably not going to be a good mark, because if you apply for that, for the trademarks office, they will just knock it back and say, well, look, anyone who's offering naturopathy services in Brisbane should be allowed to describe the services that they're offering as Brisbane naturopathy specialists. So you should not be allowed to have a monopoly over that phrase. So pick something that is not descriptive of the services that you're offering. Second thing is pick something that's quite unique. So with those girls, their mark that they had chosen, it wasn't something that was descriptive of what the goods were that they were trying to make, but it was a very common word that a lot of people use. It's very popular, and so you find that, okay, even if you can get it registered, maybe someone else has a registration for something quite similar, and you find that ultimately the scope of protection afforded by your registration is not that broad. Whereas if you register Xerox or Lululemon or something like that that's quite unusual, then you find that you have a broader scope of protection, and you've got a lot more scope to argue that if anyone tries to register something that's even remotely similar to yours, you'll be able to argue that it's too similar and that they can't do it. This next thing is think about something that's broad enough to allow for expansion. So I recently had someone, and she wanted to call a mark something pops, because she was going to make ice blocks, and you call them sometimes pops. And that's fine, but okay, what if the business goes really well? She's selling all of these ice blocks, and now she also wants to sell a different product. Or if you call you've got naturopathy services in your name, and then you find, oh, hold on, I want to expand, and I also want to offer massage services. Where if you've got a limitation in the trademark itself, then that becomes difficult for you to expand. So better to think of something that can cover a range of goods or services that you might potentially want to expand into later. Okay, then the next thing is once you've sort of picked something, check if it's available on ASIC as an ABN, as an ACN. Check WHOIS, which is a domain name registry, to see, okay, is it available there as to register as a domain name? And check all the relevant social media sites, Twitter, Facebook, Pinterest, any of the big blog sites, to see if it's available there. And this is for two reasons. The first reason is, well, if you can get a trademark, you want to be able to use it consistently across all of these things. So you're going to want to have a Twitter account that is registered, it uses that trademark. And the second thing is that this is a really good indication of whether other people are already using that trademark, because if they are, the likelihood is they've got an ABN they name something for that trademark. So if you've done all of those things and it looks like, okay, yep, I've picked a good mark, it's going to cater for my needs, and it's available, then the last thing you do is conduct a trademark search. So you go to the Atmos database and you see whether it is actually available. Right, so when you've done your search, you need to evaluate your results. And one of the important things to think about is it's not just exact identical marks that are going to be a problem. If a mark already exists that's substantially identical or deceptively similar to yours, that will also be a problem. So it can be a little bit hard to figure that out, and it's quite a subjective thing. But if you need help, then that's when you go to a lawyer. Okay, so this is one way of finding out if a trademark's available. The other way is if you don't do any of this, you just pick something and you charge ahead, and then it's a bit of a nastier way, because you'll probably end up, if there's a problem, you end up getting a cease and desist letter from an angry lawyer saying, okay, well, you're infringing my client's mark, and they demand that you immediately cease and desist from doing that. And the client dictates how long you give, but often the client will say not immediate, so we'd give something like 7 days. And if you can imagine, okay, you've got a shop front with the trademark on the front, you've got all your letterhead with the trademark on there, you've got all that goodwill, the clients know you by that mark, maybe you've advertised, you've got your website, all those things. Changing all of that in 7 days is extremely expensive and it's extremely stressful. So better for you to get it all sorted at the beginning and then save yourself that sort of drama later on. All right, so once you make sure that it's available, then you apply for registration of it. I've got to pick on someone, so I thought I'll pick on Endeavour because, I mean, I went to Endeavour and I love Endeavour and think it's doing amazing things, so I thought they'll probably forgive me for picking on them a little bit. But if you apply for registration of your mark, try and pare the mark down. So you might have a logo and you might have the name, like whatever your naturopathy or I don't know, acupuncture or whatever your practice is. Yeah. So you probably want to consider, okay, well, should I register them separately? And is there any component of the mark that I can leave out because that's not really necessary? Because the more components you have in your mark, the easier it is for someone else to come along after you and say, well, my mark's distinguishable from this mark because my mark doesn't have that, you know, the star component, or it doesn't have the big E component, or whatever. So the less you have in the mark, the broader the scope of monopoly that you're going to get by getting that mark. Okay. When you register it, you need to think about what goods and services you're going to cover. So you don't just register a trademark and then you get the protection of that trademark in relation to all goods and services. You have to designate which ones. The goods and services are classified into 45 different classes, and you pay per class. So you don't want to cover every class, and I've seen people do it and it's terrible. I've got one example here where someone applied in all 45 classes, $200 per class, so that's $9,000, and then the application just lapsed. You know, I don't know about you, but I would far rather have that $9,000 so you could holiday or buy a car or do something really good with it than just waste it. Yeah, I know, but anything. Yeah. It'll all be nice. So don't go overboard. Don't cover every single class. But also, don't forget goods, because you know, a lot of people don't think about it. They might say, oh, well, I'm providing nutrition services, so that's all I'll cover. But you might recommend to a client that they buy a particular vitamin or mineral supplement, and you're actually acting as a retailer for that vitamin and mineral supplement because you buy it wholesale from Metagenics or something, and then you retail it to your client. They buy it from you. So in addition to nutrition services, you're also providing retail services. So just really think about what are all the things that I'm doing and make sure you cover them all. And another good thing to think about is trademarks become vulnerable to removal for non-use 5 years after they're filed. But within that 5 years, even if you're not using the mark in relation to a particular good or service, no one can attack it. So if you think, well, I'm only providing nutrition services now, but I think I'll probably finish my second degree in massage within the next 2 years, and then I'll also start providing massage services, well, add that now, because if you cover it now in the current application, then you'll be good to go. Whereas if you don't cover something now, you can't add additional goods and services later. You have to file a fresh application. So then there's the additional application fees associated with that, and also, you know, if someone started using it in that space in the meantime, then you could have problems. So you're kind of like reserving it now if you apply for now what you think you might do in the next 5 years. Everything that you would do in an ideal world, and it's just something to keep in mind if you don't have the money now and you just physically can't be spending it on these kinds of things, then you have to do the best that you can do with the resources you have, and then maybe just keep this in mind for down the track as soon as you have a little bit of income that you can sort of devote to these kinds of things. Okay.
Just pursuing actually, Hayley, Emma's written in, I've got a product at the moment I'm wanting to develop, spoken to a patent lawyer, and I've got some forms that I need to fill in to assess its patenting ability. It's a flower essence, so there's nothing new in that. And I may not be able to patent it, but I've been told that I may be able to pursue the intellectual property around it. It's a flower essence that's approached in a new way. I want to speak to you, if possible, about that and other things as well. So it's a number of things in that post. One is, you know, there's a forward-looking person, but there's so many questions around the practicalities of it. So yeah.
Yeah, well, I don't know if do you want me to address any of those things right now, or if I can definitely email her afterwards and talk to her about the more intricate sort of the specifics associated with her patent questions and what the other IP rights are that she might be.
Well, it looks like some of the questions that she's asked are going to be addressed in these next few slides. So why don't we keep going, and then of course we'll have keep the discussion going afterwards as well.
Next sort of slide is just about using symbols to put others on notice to the fact that you have a trademark, either that you're using a trademark or that you've got a trademark registered. And those two symbols are the TM symbol and the R symbol. So the TM symbol is what you use before a trademark is registered, and the R symbol is what you use after the trademark is registered. You have to be quite careful about using the appropriate symbol. It's no problem if you use the TM symbol after a mark is registered. It's just not putting other people on notice to the full extent of your rights. But where the real problem arises is if you use the R symbol before a mark is registered, because that's misleading, because the R symbol tells people you've got a registered trademark. That's what R stands for. And so if you don't have a registered trademark and you are saying that you do, that's inaccurate and it's an offence. So basically what these two things help with is, first of all, before you've got a mark registered, it just helps to establish that you have been using a mark and that you've acquired a reputation in the mark, and also that the mark has become distinctive through use. So that'll help you if, for example, you don't have a registration and someone else has started using your mark, then you can allege common law trademark infringement. And also if you pick a descriptive mark and you need to prove evidence to the Trademarks Office that it's become distinctive through use. So sorry, that's getting a little bit technical there, but basically just take-home messages, use the TM or R symbol, and just make sure you use it appropriately. Okay. So next thing is, once you've got your mark registered, then what do you do? I mean, do you just sit back and go, okay, well, I'm sweet now, or is there something more that you have to do? And unfortunately, the answer is you have to still keep vigilant. So to a certain extent, once you get a trademark registration, the Trademarks Office will do some of the policing for you. So if someone else applies for an application after you've applied for yours or you've got yours registered, then the Trademarks Office will cite your application or registration against the subsequent owner as a barrier to them being able to get their mark registered if it's too similar to yours. So that's sort of one other good thing, is that once you get your registration, someone else is doing some policing for you. But it's not really enough. What you should also do is, at the very least, every 6 months, don't let it be longer than that, check the trademarks database, so Atmos, to see if there have been any applications that you're concerned about that look too similar to yours. And also do Google searches and kind of keep an eye out into the marketplace to see if any competitors have started using similar marks, because they might not have applied for registration of them, but they might be using them. And then you can sort of, I'll talk about what you do in the next slide about what you do if you feel someone's using something that's too similar to yours. The other thing I've got here is conduct a trademark watching service, and that's probably once you get a little bit bigger and you've got the money to pay someone else to do it for you. That's a service that lawyers provide, is to, for bigger clients, check if any competitors are using our clients' marks, and then we notify the clients if that's happening. Okay, so the $200 per class is for Australia only. Something to keep in mind is that trademarks, once it gets registered, it's valid for 10 years, and you don't have to pay an annuity fee like what you do with patents. If you have a patent, every year you have to pay to keep it registered. But with trademarks, you have it for 10 years. So if you divide the upfront cost by 10 years, it actually becomes quite cheap. So that's one benefit. In terms of the international avenue, there's a couple of options. Either you can appoint an attorney in a foreign jurisdiction, and they can file the trademark application directly in that jurisdiction for you. And the other alternative is to file an international trademark application through IP Australia based on your Australian application, and designate the foreign jurisdictions that you want that international application to cover. And the fees associated with doing each different option are a bit different. So if you file directly through a foreign agent, you'll get the foreign agent's fees, so it can be a bit higher. Whereas if you file directly yourself through IP Australia, it'll be generally cheaper. And it really depends what jurisdiction you want to cover, because every jurisdiction will have their own official fees. So that $200 per class fee that I mentioned, that's IP Australia's official fee. But, you know, Japan will have a different official fee. China will have a different one. So I can't really give you, I mean, if you want to email me afterwards and tell me exactly what jurisdictions you're interested in, I can give you the exact fee for that jurisdiction. If you find out someone else is using your brand, first thing you need to do is get your rights as strong and solid as possible, because as soon as you start alleging someone else is infringing your rights, first thing they're going to do is try and retaliate. So you don't want to be in any way vulnerable to their retaliation. It sounds like evil, and it's probably just perpetuating the idea that lawyers are horrible people, but I promise we're not. But it is a bit sort of yeah, the retaliation is something you need to factor in. So basically, as we said before, after 5 years your trademark becomes vulnerable to removal for non-use. So first thing you need to do is think about, have I changed the stylisation of my mark? Right, so if you've filed a trademark in a stylized format, so if we go back to the Endeavour College, so see how the writing is in a particular font and all of that? If you change that font, then your registration may no longer be valid, because someone can say to you, well, you're not using it in the form in which it's registered, so I'm removing your registration for non-use. That's another reason why, and I should probably have said it before, the best option in Australia is to apply for a word mark without any stylisation, because that means that you can then use that mark in any stylised font, and you don't have to worry about changing that font every couple of years or something, because the registration will cover your use in any stylisation. All right, but if you have registered it in a stylised way and you've changed the stylisation, file a fresh application before you allege infringement by the other person. Right, if you filed it for some goods and services that you thought you were going to use, but you haven't started using it yet in relation to those goods and services, and it's been more than 5 years, it'll become vulnerable to removal for those goods and services. So if you're still concerned about covering them, you think, oh, well, in a couple more years I might start using it in relation to them, then file a fresh application for them. The next thing is, if you've expanded, so if you didn't realise you were going to go so well, but you've actually started using it in relation to a bunch of goods and services that you didn't cover in your initial application, then file a fresh application covering those additional goods and services too. All right, next things to get your house in order. Think about, have you assigned the trademark to another company but haven't recorded the assignment yet? So that means on the register it'll be like in one person's name, but the actual owner is a different person. So I'm guilty of that. I mean, I filed my trademark registration before I had incorporated my company. So I filed it as a promoter, I guess, for my company, but it still stands in my name rather than in the company name. So it is an asset of the company, not an asset of mine, and so really I should have that recorded against the trademarks register so that no one has any claim against the mark to say, well, it's not being used by the owner. The next thing is if you want it to be, so say I want my trademark to be in my name, but I want it to be used by the company that I have, then that's fine, but you should probably have a formal license agreement in place saying, well, that company is authorised to use my mark and I'm licensing the right to use the mark to the company. And then the last thing is, a lot of the time, you might get a designer to create the logo for you. So say you get people to bid on the internet and someone says, okay, yep, I'll design your logo for $50. That's a great way of getting your logo, but you need to know that whoever designed that logo then owns the copyright in the logo. And according to the Copyright Act, the copyright is only assigned to you if it's done in writing. So you really need to get a deed of assignment drawn up saying from the designer that drew the logo saying, okay, yep, all rights in that logo, including the copyright in the logo, are transferred to you, so you own it, and then have the right to allege that other people are infringing it.
Hayley, in your experience, how easy is it to get that deed of assignment?
Oh, get the designers to agree to it?
That's right, yeah.
I don't generally have a problem getting, I'm more what I find is that clients are very reticent to ask their designer to do that. They're worried that it's going to annoy the designer or something.
Yeah.
But really, the only reason the designer hasn't done that is because the designer's assumed that it's already done. I mean, the designers often don't know that that's what, you know, the law is that they retain the copyright. Designers think, oh yeah, I'm designing it for you and it's yours. So they assume it's been done. So it's really nothing that's going to irritate them if you just approach them and say, look, I just want to get it in writing that I am the owner of the copyright in this. And also just you probably also want them to waive any claim to moral rights. So moral rights are the right to have yourself designated as the person that that created the artistic works, and so you don't want to have any sort of question over whether you have to sort of specify that person as being the creator of the artistic work in every circumstance that you use that work. So you probably just have them assign the copyright and waive any claim over the moral rights in the work. And it shouldn't really be a big deal to them because most of the time they assume that it's already been done. If you designed it, then you are the copyright owner in it. The only sort of complexities are if you are operating via a corporation, then I suppose as an employee of the corporation, your employment relationship would normally dictate that the corporation owns that work, because anything, say, that I do in my employment as a lawyer with the law firm, all copyright that I generate and all intellectual property that I generate through my job is owned by the firm. So if they're designing these logos as employees of their corporation, then it's probably fine. The corporation probably owns them and they're filing the trademark application in the corporation's name, so there's no real issue there. The only real thing would be, I suppose, if they're just directors of the corporation rather than employees of the corporation, there could be some question there, but it's really a moot point because it's their corporation and they're the individual, so there's never going to be any conflict unless the corporation is sold at some point, and then the purchaser may say, oh, hey, can you just give me in writing confirmation that the corporation owns the copyright that you generated in that work, and then you'd probably be happy to provide that to them at that time because you want to sell the company. We've gone through all of the housekeeping stuff. You've made sure that your brand is properly protected, that you've got your registration in place and it's solid. Then at that point you can oppose their trademark application, or you can write to relevant social media sites. So for example, if you have a trademark registration for something and then you find that someone else sets up a Facebook page and they're operating this page in the Australian market for goods and services that are related to what you have your registration for, you can write to Facebook, give them a copy of your registration and say, can you please shut down that account, it's infringing my rights. And we do that a bit, Twitter, Facebook, things like that. It's very hard to get these social media sites to do anything unless you have that registration, because otherwise you're just alleging something and the social media site will write back and say, well, look, that's up to you. You guys sort it out and then come back to us. And once you've sorted it out, then we'll do something. But until then, we're not qualified to make a decision on this. But if you have a registration, then they'll generally be a lot more proactive.
The only relevant example I've got really is, it's just a hilarious one where when I was beginning my practice 25 years ago, I wrote the copy and I went around the notice boards and I went to the health food stores and I stuck up my ad, the A4 thing, put it in the photocopy machine, old style, and I was running a bodywork practice in New Zealand, and I couldn't believe it. One day I was at the service station filling up the petrol, and I saw this guy advertising massage, and I walked over to it, and it was exactly my copy. It was just word for word, just got cut and paste before cutting and pasting had been invented. It was hilarious. So,
that's pretty brazen.
Well, it was hilarious at a service station as well. So anyway, what to do about that? And in fact, the reality was I was leaving to go overseas to train to end that life and start another one. So it wasn't even worth getting involved in it, and I just walked away from it and went weird. But I tell you, the interesting these days, especially with publishing, with blogs, with the fact that there is a desperation for good content from, everyone from newspapers and magazines and health food, journals and all the rest of it. You've got to be absolutely vigilant about what you write. And just every now and again, just grab something you've written, grab a paragraph or half a paragraph, put it in Google, and you'll be stunned, horrified, and amazed about where your stuff ends up. And my publishers of the books that I've written are in India. And I tell you what, I've seen whole copies of my books on sale for 20 rupees when the sale price is 48 euros. And it's just really interesting that we're in that sort of a world. And as Hayley said, just be vigilant and know where you stand, know your rights, and keep pushing when someone tries it on.
Well, I mean, that's frustrating. I can understand, because, I mean, the amount of work that would have gone into that, and then someone just copies it like that. And in some cases, like you've said, it's not worth it. You just throw your hands up. But, yeah, in other cases, you can get results, and sometimes people weren't aware that they were infringing, or they kind of were aware that as soon as you sort of notify them that you're pretty annoyed about it, they might back down and change. And have had that happen a lot, that all it takes is one cease and desist letter, so just telling people what you're doing is an infringement of my rights and I demand that you stop, and then you can get results out of that. So just one thing to note with that, though, when you send a cease and desist letter, just be very careful, because it is an offence to make unjustified threats that someone else has infringed your rights. So you want to make sure that what you are alleging is actually correct, and that you're very sure about the rights that you have before you allege other people are infringing them.
And also be a little bit clear about the cultural sensitivities around it as well, because in some cultures, cutting and pasting is an honour, and in some countries, if you're knocking up a quick website, it's entirely, normal and, well, normal behaviour to just look around for what's out there and just throw it up. But if you're in the middle of that, just keep pushing. Thanks.
The other thing, just what not to do, is if you think someone else is infringing your rights, don't sort of just fly off the handle and write to all your clients and say, oh, this person around the corner, they're infringing my rights. Or don't even on your personal Facebook page, be very careful about what you say, because there's cases now going around in Australia. You may have heard of that, Folly and other cases such as that, where people are getting charged with defamation for doing these things. So write to the person who's doing the wrong thing, but don't write and talk to everyone else about it. So just be very careful how you defame or how you talk about other people. All right, so just a couple of other sort of side issues. We've talked a lot about trademarks, but a side issue is copyright, and I guess that's related to having your website copied or your book copied and things like that. Copyright's different to trademark. So your trademark is the brand, so the name of your practice or the name of your flower essence or whatever you're selling. But copyright is an artistic work, so the logo that you create, because that's a picture that you've designed, the book that you've written, a photograph that you've taken, and then for other people who are a bit more IT focused than us, software that you've written, things like that. All of that is copyright. It exists automatically, so it's an easier one to get than a trademark. Trademark, you generally need to either acquire a significant reputation in to claim common law rights, or you need to register. But copyright exists as soon as you create that work. Copyright is owned by the author of the work, or as we discussed before, it's owned by the employer of the author of the work or the assignee, which means the person that the author sold it to or gave it to in writing. Copyright lasts for 70 years after it was first published or offered for sale, or if it wasn't during the lifetime of the person who created it, then 70 years after that person passes away. So it does have a finite period of time. Trademarks, as we said, is 10 years, but it's renewable at every 10-year increment, so it's renewable indefinitely. So just copyright considerations to take into account when you're setting up your website. Don't be one of those people that is copying and pasting other people's work. Write your own text, and also don't just, it's easy to grab photos, pretty things off Pinterest and stuff. Don't do that, because the person that took that photograph owns the copyright in that photograph. So you'd be infringing their copyright if you put that photo on your website without their permission. So better to take all your own photos and put your own unique content on the internet or wherever you're publishing those pictures.
Great question just popped up from Christine. Does copyright apply to recipes? For example, I make aromatherapy treatment blends. Is that copyright or is that trademark?
I think what I would protect a recipe more in is in terms of, I guess, a trade secret. So I would keep it confidential. That's the best way of keeping it, because copyright is only the exact written presentation that you have. So someone could modify it slightly and they won't be infringing your copyright, and it's not a trademark. So really the best way of doing that is to keep it as a trade secret, which means keep it confidential information. You can disclose it to other people, say the manufacturer, if you need a manufacturer to know what that formula is. But when you disclose it to the manufacturer, have them sign a confidentiality agreement that this is confidential, it's your proprietary material, so it's your trade secret, and they're not in any way entitled to use it or disclose it to anyone, and the only basis upon which they can use it is for manufacturing of the product for you specifically or anyone that you authorize. GetUp's this strange thing. It's kind of like the vibe. It's basically your overall appearance of, if your product or your overall appearance of your shop front or your I guess your massage practice front, it's the overall appearance of your website. Basically what it means is your overall appearance can't be exactly the same as someone else's overall appearance. So maybe the specific trademark is different and maybe the specific writing is different, but you've done it in a layout and in colouring and in everything that looks very much like your competitors. So someone might go to your website and think that it's your competitor's website because they look so similar in terms of colouring and layout. All right, that is an offence. You can't do that. So you need to be careful that you're putting your own stamp on what you do, that you're not making yours look so similar to someone else's that the public's going to be confused. Because if you do, then that's misleading and deceptive conduct and it's passing off at common law. So that's just another little thing to keep in mind. I think this is the last slide. I'm getting towards the end. Just about when you're at the process of maybe selling your business, or if rather than set up your own business from scratch, you want to buy someone else's business, because I know that can happen. Maybe someone is looking at retiring and you're just graduating, so it's like a good synergy and they can pass over their business to you. So these are some of the things that you should take into account. One is, what is the value of the IP assets that that business has? Because obviously when you buy the business, you'll probably be buying whatever stock they currently have in the storeroom. Maybe you'll be buying the chairs and the tables and everything, the tangible things that they own, but you'll also be buying the goodwill that they've built up through however many years of practice. Maybe you'll be buying the trademark registration that they already have and all of those things. So you need to figure out how much is all that intangible, that intellectual property worth, so you're not paying too much, or if you're selling it so that you're not selling it for too little, that you're factoring all of that in. There are accountants that specialise in it. Unfortunately, it's a bit hard to really get a clear idea on how much it's worth because it's an exact science. But one thing that you can do to value it is to keep a record of how much you've spent along the way. So when you file your trademark application, keep that receipt. Just store it away somewhere, so in 10 years' time, when you go to sell that business, you'll remember, I spent that much on getting that trademark registered, so I need to factor that in as one of the business assets when I go to sell the business. The other thing is, before you buy or sell, well, normally before you buy the business, do your due diligence. So make sure that they've got all their intellectual property registered, because if they don't, then you might buy the business and then you try and register the intellectual property and you realise, uh-oh, it's not available. And then you've paid all this money for the goodwill in the intellectual property that the business has, but in reality you have to rebrand everything, and so you've paid all this money for something that's of no use to you anyway. And the other thing is, this is a bit technical legal speak, but try and get the warranties and indemnity clauses built into the sale contract. So that basically means that the person selling you the business warrants to you, promises to you that they own the intellectual property that they are purporting to give you in the sale, and also that they say if they don't own it and you get sued by someone or something, that they will pay you for what you lose because of their sort of breach of warranty. So there's just some things to try and, I mean, if you're buying the business, maybe get your lawyer to look into that. Another thing, and this is probably a whole nother webinar topic, but I just thought I'll throw it in there because we do a bit of this in our intellectual property team, and that's privacy considerations, because it's a really important thing for I keep saying naturopaths because that's what I study, but for anyone who's in the health industry to think about, because the Privacy Act normally exempts anyone earning less than $3 million per year, which is probably most of us, but the people who are storing health-related information, like you guys, are not exempt, and that's because health-related information is so sort of personal that it really, the government thinks, okay, well, anyone storing health-related information needs to be held to account and make sure that they're keeping it very private and very safe. So all naturopaths, all health practitioners, acupuncturists, massage therapists, all of you should really have a privacy policy in place, and also these other things called collection notification statements, which basically means that it's specific to the particular circumstance where you'd be collecting information, and in those circumstances you give that notification to the client about what information you're going to collect, how you're going to store it, what you're going to use it for, who you're going to disclose it to, and then, you know, promising them that telling them that your policy is that you will de-identify the information once it's no longer required, and that sort of thing. So yeah, aside from IP protection, privacy protection is really important too. Okay, so if you need any help or you have any questions, I've put my email address up there, so feel free to contact me anytime. I love talking to health-related clients. It's my sort of favourite part of my job. And that's the end. Thank you very much.
Stunning. Stunning, stunning, stunning. There's a lot there, actually. I've been doing this every day for 25 years, and I can think of, if I remember going back to when I was out for 3 years or 5 years in practice or 10 years in practice, the questions I had around all of these things were different as I evolved and as my practice changed and I started doing different things like teaching and writing. So it's just so valuable, what you've been telling us there, and a lot to chew on. You're going to get an email from me very shortly, actually. I don't know about you, but I'm serious.
Well, I'm excited because I'm just from you and Riley, and some of the questions that have come through, it's been really good because it's felt like it was maybe relevant to people, so I'm pleased with that.
No, I'm done actually, just a really stimulating conversation. It's not often, you know, when we're in natural medicine or aromatherapy or homeopathy that we sit down, we talk about the legalities, because at the end of the day we love people, you know. We love people and it's all good, you know, in our consultation rooms, just until it doesn't. And then one day it doesn't. And it's really, really important to keep your hand on the handbrake and just remember that, you know, we are in a litigious world, and it's really important, basically, whether we like it or not, to just be mindful of the specifics and the legalities and the ethics and all the rest of it. So from my point of view, thanks so much.